questions publicly. It's going to be here, you can ask questions. I'm going to talk about our portion of it, not from the court's interpretation, not from an attorney's perspective. There are attorneys that just specialize in this. But this is where we see it and how we handle it currently. And this stuff's always changing. During COVID, it was horrible. I don't know if anybody had rental properties during COVID, but it was a nightmare. It was a nightmare for us. Literally, we got a call and it was like, shut it down. And I couldn't believe it. So our writ is basically just a legal document. Next one. Courts. Writs can be issued by these three courts. The only thing we ask, especially in Hillsborough County, is if you for some reason ever get an eviction from the probate court, which is basically wills and stuff like that, please make us aware. We have had people commit suicide when we went to serve these. We've had people try and harm us because it's coming from a family. It's a family matter, and if we don't pick up on that, we can be hurt. So we just ask, hey, I got this through the probate court, just let us know. 99% of the time it comes from the district court, or the circuit court as they call it now. And we get these from the plaintiffs or the attorneys. Some people do this themselves, some people hire an attorney. It's not rocket science, but sometimes if you've got too many properties, it's worth hiring a lawyer to do this for you. Your time is valuable. You have other stuff to do. And these guys specialize in it, and they're going there anyway. There's two steps. One's the demand for rent, one's the eviction notice. You can get these right on the court website if you need them. If you didn't know, years ago you had to make it yourself. The court streamlined it, and they added it on there a couple years ago. Next one. These don't have to be served in hand. Other states, they do. Well, guess what? They're not going to open the door for me. I go to do the eviction, they don't open the door.
I didn't hear you.
And we're taking the door down with a ram. And we do that. We do take the door down with a ram. If they're not coming out, we will take the door down. I've taken the door down with a backhoe, because they had it so, and sadly the guy had 200 cats. I got pneumonia poisoning, and I no longer smell anything. So don't worry about giving that back, I won't.
It's really bad.
But, yeah, so I no longer smell because the guy had 200 cats in there. We've had some very, very hairy evictions, and I'll talk about that in a bit. But these can be served above. These can be served on the door. So it doesn't have to be served, the demand for rent, notice quit, doesn't have to be served by us. You guys can serve that if you want. We're more than happy to do it in our county. I think the other 9 counties are more than happy to do it also. And we have deputies that just do civil in Manchester and Nashua. For a business, it's a little different if you have commercial property. If you have questions about that, come see me after. It's a little bit different. We did get this a little bit streamlined a couple years ago. Why? Because we had a property owner, just like yourselves, who went to the legislature and said, this is a problem with the business stuff. If they abandon the business, how do I serve them? I can't serve them above. So the legislature came up with a way of, you know what, leave it there and send them a copy via mail. But it took that act, it actually took a legislative act to get that changed. Next one. Landlord and tenant forms. Again, don't try and memorize these. I'm just gonna go over it real lightly. It's not as confusing as I might make it seem right now, because I'm throwing a lot of stuff at you. Next one. So demand for rent, simply that. You're demanding the rent. You're saying, hey, you haven't paid, it's been 10 days, and you're serving this. You're nice people. You don't want to wait. I don't want to. No, don't wait. When that rent is due, go ahead and serve it, because heaven forbid there's an issue. It's just going to delay the time. And it's not that you're being cold-hearted. You all have mortgages to pay. I have seen property owners lose their property because they were nice people. And there's a difference between being nice and sacrificing yourself. So go ahead with this. So this is very simple. You fill it out. It's going to be another sheet, front and back. It's self-explanatory. Next one. This gives you some information about mediation and different options that the tenant can choose. Next. It's 7 days. If they owe you back rent, it's 7 days. New Hampshire doesn't mess around. In other states, it's forever and a day. The only state that's quicker is Texas. Texas shows up, it's like a 3-day notice, and then the sheriff shows up with trustee inmates and puts all your stuff in the curb. Same thing in Washington, D.C. Washington, D.C. has no county law enforcement, so evictions are done by the U.S. Marshals. So when they eventually show up, and you get a marshal there, not only is he grumpy because he's been punished to do this, he puts all the stuff in the curb also by professional movers. If for any other reason they're too loud, they're smoking marijuana on the property, they're not parking their cars, or you know what, I want to remodel the property, it's a 30-day notice. That's it. 30-day notice to get out. That's the difference. Next one. Eviction notice. This used to be called notice to quit. It's a habit I can't break. I still call it the notice to quit. Hasn't been a notice to quit since 2006, but I'm very old. That was not a joke. So, next one. Again, eviction notice. You serve this at the same time as the demand for rent. It's served 1 minute after. You can serve this, we can serve this, or anybody over 18 can serve both of these. And again, the only difference this is going to have is they owe you rent, which is probably the reason you're doing it. It's a 7-day eviction notice, and you serve it to them in hand or abode. It doesn't go either way. We can do it, you can do it. And this is all available on the general court website. You put all this stuff out. Next one. This is just the back. It asks you some simple questions. Check the box as you go down. None of it, you don't need a law degree to do it. That's the 3rd page. Federal CARES Act. So during COVID, we had to start serving these. Next one. This is still on, we still have, the court's still requiring these. I don't know why. In my opinion, COVID's dead. I mean, I literally have COVID right now.
I'm not worried about it. I'm not worried about it.
But we're still serving this. Basically, this only applies is if you're federally backed, they're on some type of government assistance, somehow the federal government's involved in your business. Otherwise, and you still have to do this, but you're just gonna check, no, it doesn't apply. But it's still something that's still in place. I'm hoping it disappears on January 1. If you didn't know, typically legislation changes on January 1 or July 1st. We're just hoping this goes away because it scares landlords and it's just not necessary. And that's just the back. It gives all the federal laws. Affidavit of damages. So, some of these people don't respect your property. And I'm going to show you some pictures later. They're going to give you nightmares. There's a reason I don't own property. So you can recoup some of your losses. Back rent is one thing, but damages that they cause to the property. The problem is there's a cap on this. And rents now are going for like $2,500 a month. So if you let this slide for 3 months, you're never going to recoup all that. Don't wait. Again, don't wait. You're not being cold. You're just being prudent and protecting your property. Next one. Affidavit of military service. This is real simple because we don't really have that many service members in New England since Fort Devon's closed. So, next one. Again, you just fill this out. The court just wants to see this. That's it. It's not scary. It's not rocket science. If you forget this, the court's probably going to tell you, hey, you need this. I will tell you this. Some courts do operate a little different than other courts. And just nod politely and, okay, no problem. We deal with it every day. And some courts might, oh, I don't need that, I do need that, whatever they want, and just get through it. Next one. Landlord and tenant writ. So, they didn't move out. You gave them 7 days notice to quit. They didn't move out. Imagine that. Because guess what?
I didn't get it.
But I served it to you in hand. Oh. I've had that happen so many times. How could you forget me? I'm memorable. I am. And I'm friendly when I serve this stuff, because I'm grilling them. How you doing? This and that. This is what the paperwork's about. Blah, blah, blah. You're still here. So this is the landlord-tenant writ. This gives them the option to go down to the court and say, I shouldn't be evicted because of X, Y, or Z. Most of the time, they shouldn't be evicted because they don't want to be. There's no legal recourse. It's they haven't paid their rent. They have no place to go, and now in this economy, it's very hard to get other places to go. So they're desperate to stay there. You would think that they would do whatever they could to stay where they are, but sadly, my agency does 1,000 evictions a year. We send out teams of, we rotate the days right now, but we send out 3 to 4 teams of deputies doing this stuff all the time. And sadly, it slows us down because people we're evicting have warrants. Well, that takes time. They don't open the door. Now it's a SWAT call, or we call our wet team, which is our warrant entry team. But they're going to be served this. It's very self-explanatory. The only question is, right in here, it's got a box for return date. Right here, return date, and that's basically going to be 8 days from the day we serve it. Because the court doesn't count the day we serve it, so that's going to be filled in by us or by the court, and that's going to give them 7 days to go down and file for a hearing. And they can go down to the court and say, I'd like a hearing, and the court will, give them a court date. The problem is, now you've got a couple days tacked on. We're going to get to it. Typically it's the next week, but it's a way to slow it down. Next one. Again, just the back. The only thing is, when you get these back from our county, we're not going to fill this out. We're going to give you an actual affidavit of service. We're going to give you our own letter with our own signature on it instead of this. That's a little fancier. Next one. Next one. You don't have to file this where you live. So let's say you live in Berlin, but your property is national. You can file this in the Berlin court and have it served by us down there. I have seen judges say that's not fair, it's too far, and move it to their court. Whether that's by the letter of law or not, I don't know. They're the judge. I wouldn't do well in jail, so I'm not going to argue. Because I'm pretty. What's your name?
Maybe.
You're not laughing at my jokes.
I'll try.
All right, you'll try. I wrote these down last night. All right, enough of that. So, I've only seen that overturned a couple times, and normally it's like the landlord lives in Salem, the property's in Nashville. I don't think that's terribly far to go. But I have seen it reversed, but give it a shot. There's nothing wrong with it. It's by the letter of the law. Next one. Appeals. So, you go to court, they haven't paid your rent. That's a fact. You did everything right. You filed for the hearing. They went down, they had a hearing. The judge said, writ of possession will issue in 8 days. Boom. Should be over. Nope. They go up to the New Hampshire Supreme Court because that's where all landlord-tenant appeals have to go, is New Hampshire Supreme Court. They couldn't make it to the door for me, but they can make it to New Concord for the New Hampshire Supreme Court. And they'll appeal here. This can go 1 or 2 ways, or 3 ways. One, they'll hear it. They'll actually have a hearing for it. I can't remember that happening. I know it has happened. I can't name a case where it has, but it definitely has happened. They will deny it and send it back down, or they will grant it. But again, granting it and hearing it are pretty rare up there because they see through it. And they're dealing with murder cases and whatnot and appeals on that. They don't really want to deal with a little landlord-tenant writ, and they can see through the guff. And to have Supreme Court justices sit there and hear a landlord-tenant hearing, it's pretty rare. The issue, though, is sometimes the circuit court reverses their order. So we've done everything. Then they turn around and say, let them back in. And it doesn't happen that often, but it has happened. So that means we evict them twice. It's very rare, don't let that scare you, but don't be shocked if it ever happens to you. Next one. Again, there are recourses for both the tenant and the landlord. There's something called the 540A, which is basically a landlord-tenant restraining order. Landlord and tenant can both file it. Problem is, it typically gets filed by the tenant right after I serve the landlord-tenant writ. Oh, it's unsafe to live here. But you waited till I showed up to do something about it? And again, the court sees through this. Oh, you happen to come down and file this the day after the sheriff served you paperwork, or the day before the sheriff is going to go evict you. And we never tell them when we're coming, by the way, and I'll go over that. But it's called 540A. It's also good for you, though, if your tenant is highly destructive, just damaging the property, and you need some type of recourse. You can go down to the court with this and say, hey, I need this. And the judge can put anything in there they want. You know, tenant shall not do this, shall not do that. The judge could say the National Police are hereby ordered to remove them immediately without delay, or the sheriff's office. It's whatever the judge says. And again, the court sees through this, but it's there for you and for them. Writ of possession, this is the point we're trying to get to. This is what we're trying to get. This is the holy grail. This gives us the authority to remove them. This is basically like a search warrant. You have no expectations of privacy per the per the United States Supreme Court when I'm doing this. So you can't come in here. I can go anywhere I want because I'm here for my safety, and you had more than enough notice to get out. This doesn't get served to them. This gets brought to us. We will give, in Hillsborough County, we will tell you, we'll give you a call. When we get a number of these lined up, we will go out and we'll do it. And again, it's done kind of like a mini SWAT team. Sadly, of the 1,000 evictions I do a year, I'm evicting the same 600 people over and over again, a lot of the time. I once evicted a woman in the morning, and I served her an eviction notice in the afternoon. She was a piece of work. She was also dating her former foster child. Yeah, she was a prize. She didn't like me, imagine that. It was hurtful. But again, you get this, we go, we enforce it. What we're gonna, does anybody own property in Hillsborough County? Woo! See? One of the original 6 counties, the best. All we ask is, A, you don't tell the tenant you have it, and that we're coming. Because what happens is they lie in wait sometimes. They barricade the property, they let their pit bull out. Why they all have pit bulls, I have no idea. Or they arm themselves. But this gives us the authority. You're gonna show up, you're gonna stand out by your car. Because family matters and evictions are the most emotionally charged thing we do. And people have a false sense of ownership when it comes to being evicted. A foreclosure eviction goes way up here because they have a false sense that this is their property, they still own it. Unless they ever had that deed in their hand, they never really, really owned it. I've had people cut the floor joists out of the floor. Ooh. So I'm there doing the eviction and I'm standing on carpet. And this massive deputy grabbed me and pulled me back because I was standing on carpet with nothing underneath me. I've had booby traps. I had a knife stab me in the face once at an eviction. We had one where they left the gas on, so we'd blow up. Problem is I can't smell, you remember? So I'm in a house filled with propane. I have no idea what it smells like. So these can be dangerous, especially the foreclosure. So we might treat the foreclosure ones a little different. There was a time we were doing 10 foreclosures evictions a week in Hillsborough County. We rarely see these because the properties have value again. There's always a buyer out there ready, and they do cash for keys a whole lot more. Next one. And this is what we stick on the door. Basically, if they go in with this sticker on the door, you call your local police and they go to jail. The police departments in our county all know that we're in their county, or they're in their town doing these. They know what's going on. They know nobody should be there. Now, after this sticker's on the door, you have the right to go in there as you see fit. You only have to keep this stuff for 7 days. It used to be 45 days. 45 days holding on to somebody's stuff. You could move it out, but you had to move it to a bonded storage facility. And you still can move it out, but you can't charge them for that bonded storage. So you incur that cost. It's for 7 days, I say leave it there. Plus you also don't know what's in there. You know, we deal with needles all the time in Manchester, we deal with needles all the time in Nashua. Just absolute filth. Next one. Myths, can't be evicted in the winter. Not in New Hampshire, live free or die. You know, some of these states, I don't know how they hate property owners. Our country was founded on owning property. If the king loved you, he gave you property. You can't evict with children. Nope, you can evict with kids. You can. Like, you know, it's sad, but you can be evicted with kids. And if you put your kids in that predicament, you know, that shame on you. And they'll use their kids as a weapon against you. And that's where the attorney comes in. Because if you have a soft heart, not that attorneys are cold, but they're removed. They're removed from the problem. They have to be told. I wasn't told you were coming. Of course you weren't being told. You'd lay there with a gun. And again, we've had people arm themselves and we're coming. You know, it's a sad thing. The landlord can't be in the apartment to remove the, no, you can be in there, it's your property. Once we put that sticker on the door, you have every right to be in there, move their stuff out, start repairs. Because again, it's a business. You're in this to make money, and at the very least, you're there not to lose money. And apartment sitting empty is cash gone. Tenant has to be served any of his writs in hand. No. I wouldn't serve anything in hand. No, the court doesn't see it that way, because why? They just wouldn't ever open the door. Why would you ever open the door? That's the sheriff. I'm not gonna open the door. It's hurtful. I've served people in hand. I didn't get any notice. You didn't get any notice? No. Well, I pick it up off the table. That's my signature. Like, how did you forget me? Could you forget me?
No.
That's my first name.
Mike.
It means one who's like God.
Mike.
Yeah, there you go.
Mike.
So I wasn't served anything. Yes, you were. And we find it in the house on the table. It's ridiculous. Years ago, they used to get a default notice mailed in, and it was pink. And we played a game called Find the Pink. And if you found the pink slip, it was like, what do you mean anything? You got your mail right here. And not only do they get the stuff from us, the court mails them a notice of default saying, hey, by the way, get out. But, next one. But we deal with some horrible stuff too. Animal cruelty, we don't see it that often. These people went